salute you all. Thanks for being on and thanks for listening. So basically today we are looking at the introduction of law or the foundations of law as a course unit basically. And today we are going to more so emphasize on the classifications or the divisions of law basically. For you to understand the concept of other course units or the law itself, we must start with the fundamentals or its foundation, which is this course unit that was brought in so that we can understand the core values of law basically. So today we are going to look at the foundations of law, and we are looking at the classifications or the divisions of what? Of law basically. And to move on or to go further, the law is divided in two. There are two major broad aspects, which is the civil and the criminal. Those are the major broad classifications or the divisions of law. So the good book about the fundamentals for you to understand law, there is a book of Granville Williams. That is a good book. When you read through, you can understand the core fundamentals. So, though actually it has the English concept, but still our law develops from the English concept. So it is a good book for your understanding of the law. So basically, I've told you that there are great fundamental divisions. That is the civil and the criminal. But however, there are also others that we are going to look at. And basically, I'm going to look at the broader ones before coming to the two major ones. So there is written and unwritten. You get basically, when you are classifying, you must put written versus unwritten, or written and unwritten. The reason as to why we reverse both of them is because realize that this one is the opposite of the other. They are just the opposites of the other. You get, but all they are concepts of what? Of law. So when you look at written and unwritten, realize that written law, this is law that is documented, or the law that is compiled and written down. And for example, the Constitution, the Penal Code, among others. But unwritten, this is law that is not documented. It moves on norms, beliefs, cultural behaviors, you understand? But basically, for them to be recognized, they must be in continuous usage. You understand? For example, let me give an example under customs. Realize that in Uganda, for a lady to greet, you have to kneel down. Although nowadays it is being diluted, you had to kneel down. It wasn't written anywhere, but if you greeted someone without kneeling down, it was like an offense in Uganda by that time. But it wasn't documented anywhere. So that is the unwritten law that they talk about. You get even equity and the common law, they are all unwritten Unwritten laws. Then another classification, we have the public and private. For the public law, it deals with the state and people. You get, it deals with the state, that is the public. It is there to regulate the public officers or the state itself with its individuals. That is the public The public law. But for the private law, for it deals between individuals. For example, the law of contract, tort law, among others. But for the public, it is the state and the individual. For example, criminal law. Criminal law, you are versing the state. DPP, Uganda, you are versing the state. So that is a public law. But for private, it is between individuals. Law of contract, land law, family matters, that is a private, because it is between a person and a person. The state is not involved, so it doesn't make it public, unlike the criminal matters. You understand? So that is the difference. Then when you go further, you have now the criminal and civil. Criminal and civil, I've told you, these are the core ones. For criminal, basically, it is law. That is the law that is between the citizens or the people and the state. That is criminal law. But for civil, that is between a person, individuals, between individuals. That's why for criminal, it is presided over by the prosecution. which is the state. But for civil, it is presided over by the defendant, who is the aggrieved party. You understand? That is, and for criminal, that the punishment is imprisonment. But for civil, it is damages. You are just asking for damages. So note that in mind. For civil, there is only punishment of imprisonment. But for criminal, punishment is imprisonment. Civil, you are just looking for damages. That's why under civil we have land matters, family, tort, contract. But for criminal, murder, rape, robbery, theft, adultery was no longer an offense. So basically that's the difference that I can give between the two. You get? Then we have substantive and procedural law. Substantive law, that is the law that provides, it is the law that provides for the punishments and the what? And the offenses. For example, the Penal Code, the Contract Act, it just provides that, say Section 75 of the Penal Code Act provides for affray as an offense. Still Section 75 provides for the punishment of affray. But that is substantive. It just provides for the offense or for the punishment. But for procedural law, this is the law that provides how you can proceed on a particular charge or a particular indictment. You get procedural law, basically we use the Civil Procedure Act and the Criminal Procedure Act. Realize that for them they show how you can proceed in the courts of what? In the courts of law. How you can proceed if it is along, you have said affray is the offense. How am I proceeding to court to get justice? So that is the procedural that I'm talking about. But for substantive, for it just provides for the punishment and the offense. But procedure shows the steps taken in getting justice. Then you have the national and international law. The national law, this is the law that acts within the jurisdiction of a particular country. That's why sometimes it's called also the municipal law. But for international, it is the law that is between countries. For example, UN, ICC. So it is between countries. Treaties signed by various countries. It is international, Interpol. But for national, it is within the perimeters of that particular country. Then we have what they call common law and equity. What do I mean by common law and equity? Basically here, common law, this was brought by the concept of the England people. More so, they used cases, more so common law. But for equity, basically I'll use the maxim that equity follows the law. Equity came after common law, and it had to follow common law, because equity is just fairness. You understand? So equity was brought in just to provide that fairness that wasn't provided by common law. So common law, that was unwritten law, and it was the law that was based on precedents, that is case law, already decided cases. But equity came in to give fairness. Or, for example, under equity, the judges, you could use your own consensus or your own consensus, your own knowledge on a particular case. Unlike common law, it was rigid. You could base on what was decided before. But for equity, you could apply some fairness, some reasoning, as the judge could understand the particular case. You get? Here, currently, the common law and equity were brought in Uganda through the order in Council of 1902. When you read Article 15 of 1902 order in Council, it provides for the imposition of the white man's role into our day-to-day events. So basically, note that in mind, or bear that in mind. When you read the Judicature Act, it also provides that common law and equity must be applied concurrently. So bear that in mind, basically. So that is the brief that I can talk about. The classifications or the divisions of law, basically. Those are how the law is being classified. But this is a good course unit, the foundations of law, or the introduction of law. This is really the fundamentals of the law that is being ahead. So thank you very much. Thanks you for watching. Any question, anything that you feel that is a bit confusing, place it in the comment section so that we can attend to it keenly and we understand the law. Thank you very much for listening. Stay blessed.